Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, this is going to be a quick video. We're going to try to get everyone in Washington State and Oregon up to speed on what's going on with some terrible pieces of legislation and some current litigation that's going on with both of those, because everything's kind of been in a holding pattern. I've been getting a lot of questions, and a lot of you want to know what the hell's going on. So let's spend a couple minutes and talk today and get you all up to speed about why everyone in Washington and Oregon is still waiting for a major ruling. Okay, so like I said, this video is going to be for my folks in Washington and my folks in Oregon. We got two pieces of legislation which are currently being challenged in the courts in both states, and we are waiting for major rulings. Taking Washington first. As we know, last year we passed RCW 9.41.370, which is a standard magazine capacity ban. That statute is being challenged now in two separate courts, two separate actions, one called Sullivan v. Ferguson in Western Washington, the other one called Brumback v. Ferguson in the Eastern District of Washington. We have talked to plaintiffs' counsel in Brumback v. Ferguson. That's Pete Serrano with the Silent Majority Foundation. We know that before Christmas there was an argument, oral arguments, about whether or not the court should issue an injunction against the implementation and enforcement of Washington's magazine ban. That ruling was supposed to be out already. We do not have a ruling. In fact, that ruling now is a couple of weeks overdue based upon the deadline that the judge herself set on that case. Now, if you recall from a couple other videos we did, Pete Serrano, the plaintiff's counsel, did try to file some supplemental pleadings based upon some late developing evidence that took place in the Oregon Ballot Measure trial. The judge has addressed the admissibility of those pleadings. So we do know that, yes, she has a heartbeat, and yes, she is addressing this case. As soon as we know whether or not there will be an injunction issued, we will let you know. Remember, folks in Washington, if an injunction is issued, that basically enjoins the state from enforcing RCW 9.41.370, which in essence allows FFLs to openly sell any capacity magazine that they would want to. We are expecting a ruling on that at any time. Now, for my Oregon folks, okay, the bad news is, yes, Oregon Ballot Measure 114 is still a reality. The good news is you have a fantastic judge down there in Harney County, and all portions of that ballot measure still remain enjoined. That is, no portion of that statute is in effect. Now, as we know, one of the big concerns on Oregon Ballot Measure 114 is this pre-purchasing licensing requirement. Interestingly enough, there's another governor and another attorney general in another state thinks it's a great idea now, by the way. Thanks for that. But this pre-purchasing licensing requirement was enjoined by Judge Ratio down there in Harney County for the simple reason that the state of Oregon had no clue, no idea, no freaking way that they were ever going to implement this law. It was, in fact, we talked about this before this law even went into effect. In fact, even before the election, that, hey, listen, you look at the enactment date on this law and then you take a look at what they're trying to set up. There's no way they're going to make their deadline. Well, that's one of the reasons, one of the several reasons that Judge Ratio enjoined Ballot Measure 114. The state now has asked for that injunction to remain in effect for even longer. The state of Oregon has now asked the judge to stay implementation of Oregon's pre-purchasing licensing requirement until at least March 7th of this year, roughly 2 months from now. Now, I'm going to tell you folks in Oregon, I don't think there's a snowball's chance in hell that they are ever going to have this set up by March 7th. But right now, the state of Oregon is conceding that, hey, we can't even begin to implement this. Now, in this ruling also, there is some other tea leaves that can be read here. And that is that one of the other components of Ballot Measure 114 is the closing of the Charleston loophole. We've done a video on the Charleston loophole. Basically, does it allow a state to extend statutory waiting periods beyond what federal law requires? And the answer to that question, I think, is pretty clearly yes, they do. And I think Judge Ratio has also kind of indicated that, hey, listen, any constitutional challenge to any type of additional background checks necessary to purchase a firearm are probably not going to prevail. Now, Judge Ratio was also point out that when we couple that with a pre-purchasing license requirement, we're talking about a whole different beast here at that point. But I think there is some other things that could be read from the tea leaves. So The moral of the story is, whole lot of nothing going on. Now you know why. Listen, in the meantime, if you have any questions about any of the stuff, and you know if we have any updates, you will be the first to get the information right here from Washington Gun Law. But if you have questions, you can always contact us at WashingtonGunLaw.com, or, of course, you can call us directly at 425-765-0487. Now, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.